Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know, as I'll be keeping track of the time, and I'll try to alert you when you move into your rebuttal time. The arguments are being recorded, so please stay behind the podium and keep your voices up. Introduce yourselves. You should not use the name of children or minors or victims, should that be relevant to your argument. We have read your briefs. We're ready to proceed when you are, and I would just ask appellant, would you like to reserve time?
I would, Your Honor. 3 minutes, please.
3 minutes? Very well, then you may begin when you are ready.
May it please the court, counsel. My name is Carlos Ortiz. I represent Charter Communications LLC and Chad Brindley. I'm before you here today to ask for this court to overturn the trial court's decision in this matter. The assignment of error is focused on several issues. First issue is that the trial court erred in basing its decision to find the arbitration agreement unenforceable solely because the court found that the agreement was procedurally unconscionable. Next is that the court, in arriving at its decision, ignored a litany of sister court decisions that have been cited in the brief that are directly on point and deals specifically with the charter arbitration agreement, and in this exact type of situation where there was an existing employee who was given an opportunity, in fact was given 30 days to be able to opt out of the arbitration agreement. Next, the court erred in not applying the mailbox rule, even though the court acknowledged that there was evidence in the record to show that Ms. McFadden received what I'm going to refer to and what we refer to in the brief as the solution channel announcement. Now I'm going to go ahead and move to the issue with the unconscionability. It's clear that in the trial court's decision that that in arriving at the decision to find the agreement to be unenforceable, the court expressly stated, and I quote, providing an opt-out provision that then becomes binding, specifically requiring arbitration, does not provide a meeting of the minds when one of the parties to the contract did not even read the email containing the provision. That's on page 6 of the decision. That is the last sentence of the paragraph that begins with the court analyzing procedural unconscionability.
But counsel, did the court actually find there was an agreement?
Yes, the court found that there was an agreement and found it to be procedurally unconscionable.
I was going to ask the same type of question that Judge Sutton was asking, so maybe I can follow up. Sure. I was a little confused over that too, because before, arbitration is a little unique in the way the courts analyze it, and I know it's so highly favored. And I agree that the case law does say procedurally unconscionable and substantively unconscionable. But I'm going back to Judge Sutton's question, because what does procedural unconscionability mean? Doesn't there have to be a contract before you can say it's procedurally unconscionable or substantively unconscionable?
So, Your Honor, that's an excellent question. The case law shows that you don't reach that analysis until there's actually a finding of an agreement. If there was simply no agreement, you wouldn't even reach the unconscionability analysis.
And that's what I think Judge Sutton and I were both talking about, so I'm trying to figure out here, because the court said there's no way you could say she agreed to anything if she didn't read it. Now, that may be incorrect, but then the courts say that.
So, Your Honor, what the court specifically said was, and I'm on page 6 again of the decision, first paragraph.
Page what now?
Page 6.
Okay, thank you.
First paragraph, last sentence, says, this court acknowledges that there appears to be record evidence that Ms. McFadden read the email, but an email that is opened is not the same as an email that is actually read and reviewed by an individual. In making that statement, the court has acknowledged that Ms. McFadden, in fact, received the solution channel announcement, that very email. Because if that wasn't the case, the court could have simply found she never received anything, so how could she agree to something she never received? That's not what the court's analysis was, that's not what the determination was. Given the fact...
First of all, the announcement letter, I think you referred it to as an announcement, did that have within it, like, the term arbitration agreement or anything within the announcement letter?
Yes,
It did?
yes. Specifically, the email stated, this is cited in the brief, this is a part of the record, record 9, page 15 of that record. And the announcement said, in relevant part, by participating in the solution channel, you and Charter both waive the right to initiate or participate in court litigation, including class, collective, or representative actions involving the covered claim and or the right to a jury trial involving any such claim. More detailed information about solution channel is located on Panorama. Unless you opt out of participating in the solution channel within the next 30 days, you will be enrolled. Instructions for opting out of solution channel are also located on Panorama.
So the word arbitration isn't within that announcement letter, right?
The word arbitration
We can move on.
the brief specifically says, and forgive me, I just lost my place.
Sure.
Okay. And I'm quoting again from the record 9, page 15, specifically states, and I quote, Charter has launched Solution Channel, a program that allows the company to effectively resolve covered employment-related legal solutions through binding arbitration. So to answer your question, Judge Sutton, yes, the word arbitration absolutely appeared in the Solution Channel announcement.
Okay. All right. And on the solution channel, there's a direction right to go to the solution channel. And then if you go to the solution channel, can you see the arbitration agreement right there?
So what happens is that there's a link that there are multiple ways to be able to go ahead and access the arbitration agreement. There was the announcement that provided a link to the Panorama webpage, or the Panorama webpage was the default on the default home page on any Charter employee's browser. So as soon as they would launch their internet browser, that's what would appear on the screen immediately. And through there, there was a portion there where they could click on another link in order to be able to bring up the arbitration agreement.
Okay, and just one last question, and I'll let you get back to presenting your argument as you choose. But, so was there any need for assent on the part of the appellee here? Was there a need to assent for it to be binding, or?
Well, so Judge, the answer to your question is yes, but assent could be accomplished through a variety of ways based upon the law. Ohio state law controls that issue, and we're talking about what the contract law is.
Okay.
We're talking about the offer, acceptance, and consideration. And for instance, the Collins case that we cited in our brief, that is the Northern District of Ohio case that applied Ohio law, stood for the proposition that in certain situations when you have a special relationship, inaction can equate to assent, to mutual assent. Here in this situation, Your Honor, Ms. McFadden acknowledged that as an employee of Charter, there was an expectation, obligation for her to read all of her emails. In this type of situation, if an employee would be given an opportunity to be able to pick and choose what emails they were going to read from their employer, where would we end? How would an employer be able to effectively be able to communicate with their employees, especially one the size of Charter with nearly 100,000 employees? We have to be practical about the circumstances here. She also acknowledged that in picking and choosing which emails she would read, she prioritized ones that were from leadership of the company. And the email was sent by Mr. Rochelle, who is the Executive Vice President of Human Resources. Clearly, he's a part of the leadership of the company. The fact of the matter is that despite the fact that she opened the email 4 times, she simply chose to ignore it. We find examples of, in everyday life, about situations where inaction will result in consequences for not being proactive and following through. Perfect example of this is how many of us in our daily lives have received a class action notice in the mail about a settlement, saying that unless you opt out within X amount of days, you will be included as part of the class. And there are certain consequences that go along with that. This is not a situation where she didn't have a choice. Okay? She had a choice. She could have opted out and maintained her employment. In fact, nearly 10,000 of the Charter employees did that very thing. So this was not an issue about problems with being able to figure out how to be able to use and navigate that announcement. It was clear that that they were able, that if 10,000 employees were able to do it, certainly Ms. McFadden was capable of being able to do that. I do realize that I'm going to take 30 seconds of my rebuttal time just to be able to say I fully anticipate that one of the arguments that opposing counsel is going to raise with you right now is the issue of the admissibility issue in regards to certain documents that were submitted at the evidentiary hearing at the trial court level. It's important to note that in his brief, opposing counsel did not disclose to the court that all of those objections were overruled by the trial court. And why that's important is because the Rallia, and I may be mispronouncing it, and if I am, forgive me, R-A-L-L-Y-A decision is instructive, and it's Judge Carr's one of your decisions. And instructive under Appellate Rule 3C1, it required opposing counsel to be able to file a cross appeal, and he didn't do so. So that issue, if he raises it with you, is not properly before you. I'll reserve the rest of my time. Thank you.
Thank you.
Thank you, and good morning to you all and to council. My name is Dan Petrov. I'm here on behalf of Rochelle McFadden, who's not here with us today. I want to thank you for your time. The matter's been fully briefed, but the things I'd like to talk about this morning is I see this case as an invitation for the court to view this case as not one of a litany of cases on Charter Solution Channel, but for the unique perspective that it provides. Because this case and what the trial court conducted and the record that the trial court provided presents us something that hasn't been done before in those other cases, which is to conduct a full evidentiary hearing that allow the parties to examine the poor quality of evidence that the charter actually has supporting its assertions. The trial court also allows us here today to reflect upon the Ohio case law in Harmon v. Philip Morris and Hardwick v. Sherwin-Williams, which already start to set the stage for a closer investigation of what it means to assent to an arbitration agreement. And both of those Harmon and Hardwick cases relate to arbitration agreements that were distributed by leaflet to employees, and in both of those cases, the 8th District in Cuyahoga County ruled that that is not an enforceable agreement because there's no evidence of acceptance or assent. Judge Sutton, going to your question to counsel, I think I may start there about what the trial court found. First of all, I can address that point as well as the last point about evidentiary findings by reminding us all of what the standard of review here is today, which is de novo. And while the trial court's factual findings are entitled to some deference by this court, this is a de novo review. There's no requirement that we raise a cross appeal to allow this court to make its own evidentiary determinations as to what matters and what is admissible and what is not. The trial court did not find that there was an agreement. There is some discussion of procedural unconscionability. I view that as dicta. That on page 7 of her decision, she did state, the arbitration agreement, which could only be found through a series of email and hyperlink agreements, was procedurally unconscionable. That is true. But the trial court didn't base its holding on procedural unconscionability. And it specifically stated, quote, providing an opt-out provision that then becomes binding, specifically requiring arbitration, does not provide a meeting of the minds. And that's page 6 of the trial court's decision. That holding is based on a lack of assent to arbitration. We go on in our brief to say that if there had been a full analysis of unconscionability, we believe that this arbitration agreement fails both substantive and procedural unconscionability. I think that that's sufficiently covered in the briefs. It's important to go back to what was actually presented to the trial court, in my opinion here. Counsel gave a lengthy description of the email, the solution channel announcement, what was contained in certain emails, what the links were to, and what was not. None of that is proper evidence before the court. There's no dispute that the arbitration agreement, the agreement that counsel and charter is asking this court to enforce, was never delivered to Ms. McFadden. Parties are in agreement on that. There is a dispute about whether she got an email and whether she clicked the email, but all of that even is simply argument between counsel, because the email, which is referred to in the briefs as Exhibit H, Mr. John Freeze, who submitted a declaration, as he has done across the country, submitted a form declaration stating that this is an email. In this case, when he was actually called upon cross-examination to describe the email, his testimony was that that was, quote, not the actual email known. He couldn't authenticate the document. And similarly, Mr. Vasey, who also works in IT, said that he did not generate that email, and it's not part of his testimony. So there is no evidence, no witness, who before the trial court or before this appellate court has said, that is the email that Charter sent to Ms. McFadden. Charter also has offered 2 spreadsheet excerpts, one about whether Ms. McFadden received an unknown email, and second, whether she clicked on it. But those also, there's no evidence that those were authenticated. Mr. Rees said it's a click data report, but that I believe it's maintained in a database that our internal communications team manages. I'm unfamiliar with how it's generated. These things are not proper evidence. Even if they were, There is simply no agreement to arbitrate between the parties because this is a textbook example of what some courts have dove into the matter is what's called a browser app as opposed to a click wrap agreement. We all use computers in our day-to-day life. A lot of times websites will ask us to accept terms and conditions of a website. Many of them will make you scroll through the entire agreement and then click at the bottom to do so. That's not what this solution channel site does. And to the contrary, the email, which again is not properly before the court, but assuming it were, is an email which links to a website, which in turn links to the arbitration agreement. So the arbitration agreement that's being asked to be enforced is 2 steps away from the employee. Council made an entreaty to, we have to be practical because we have so many employees. The practicalities of their workforce do not change the very fundamental principle of Ohio law, which is that contracts do not become formed and enforceable until there's assent and a meeting of the minds between the parties. And there just is no evidence in this case that there was such an agreement.
I think part of the problem, at least for me, is, like you mentioned, the procedural unconscionability is mere dicta, basically, you're saying. But it seems like the case law kind of blends that all together in determining whether there's a meeting of the minds in regard to whether contract was formed to even with procedural unconscionability. I know it's supposed to be kept separately, or it should be, but it seems like there is a blending, and it seems like that's what the trial court was doing here.
I'm happy to address that. I don't know if I want to make sure I understand your point.
Yeah.
I do believe that the concepts are blendable for this reason. I can imagine a hypothetical where there's no dispute that an arbitration agreement was on paper with 2 pens and signed. So the document would, on its face, may be evidence that there was a meeting of the minds. Both people signed this piece of paper. But because of certain procedural unconscionability components or substantive unconscionability components, the law may determine that there was no meeting of the minds when people both signed that agreement. And so I think in that hypothetical, and that's why some of the case law does blend these concepts and bring them together. In this particular circumstance, I believe the evidence is that there is no actual mutual acceptance of the agreement. And the process that leads us to that point in time is evidence that the entire process here is also procedurally unconscionable. So I think some of whether it's blended or those threads can be teased apart is dependent upon the order in which events occur. I'm not sure that it matters to the end analysis once we have the entire factual timeline to determine, okay, now we understand what the parties did, what they signed, what they did not sign, how it was delivered, and what the contents of the document are. Now that we understand all that, was there mutual assent? Do we have evidence of agreement? And does that process reveal some unconscionability in the process? And in this case, I believe Charter fails on all points. I believe that procedurally it's an unconscionable process designed to hide the ball. Trumpeting that 10% of the workforce opted out is not a sign of fairness and openness. It's a sign that that the agreement has been hidden from them. And we can't test the hypothetical, but if the agreement were presented in paper to all of them, would 90% opt in? I don't know. We won't know because they haven't been given that chance. But untangling those threads, there's no evidence of the actual assent, and even if there were, this system of sending an email, a blast email, to 100,000 people with a link to a website, with another link to an agreement that Ms. McFadden never saw, clicked on, or signed, it fails both in terms of the Harmon test of was there mutual assent, as well as procedural substantive unconscionability.
The reason I'm asking that, though, is because really the only way this can be upheld is if we determine the trial court made the decision that there was no assent, that there was no meeting of the minds, that there's never a contract formed. Because otherwise, don't you need both a finding of procedural as well as substantive unconscionability?
If this court were to determine that I agree with the first point, that if there is no meeting of the minds, the decision would be upheld. I also agree that if this court were to determine, we believe the trial court erred in determining there was no mutual assent. There was, but it's procedurally unconscionable. I mean, this court would, under Ohio law, would need to also determine that there is substantive unconscionability, which I believe there is based on the limited discussion of appellate rights, which is detailed in our brief. So the trial court did not reach that issue and did not address it, did not find it to be substantively conscionable either.
And that's what I was saying,
Yes.
they didn't address it.
Didn't address it either way.
At the very least, it'd have to be sent back for the trial court to make a determination.
If this court were,
If it's a
yes,
contract.
if there is a contract with mutual assent, yes, I agree with that point. As to just the other 2 points that were raised on the initial argument, the suggestion that the trial court ignored the litany of cases or of sister cases, I think is not correct, because those cases, as was detailed in our brief, do not involve the record examination that the trial court had in this case, and none of those cases did any employee challenge the authenticity or the admissibility or the actual process of contract formation as McFadden did, and I believe that those cases are non-instructive because of that. Specifically, Collins, which counsel referenced during argument, was a Northern District of Ohio case. There was no evidentiary hearing. The plaintiff did not challenge the authenticity of the email distribution. The court did not consider the Ohio appellate case law in Hardwick or Harmon. And at least as one can tell from the opinion, there was no discussion of unconscionability. So I do not believe Collins serves as any barometer that's helpful for analyzing the issues before this court. And lastly, absent any further questions from the court, as to the mailbox rule, we're all familiar with, but the principle is that a contract can be enforced upon acceptance. If an acceptance is mailed, that even if that acceptance isn't received by the original offeror, and the offeror cannot withdraw the offer because the acceptance is in the mail, well, this application is backwards here, because you can't simply enforce a contract by mailing it to someone and say, I can't mail anybody a contract, say I've purchased your house for $1 or I've purchased your car for $1, because I mailed it, it's an enforceable contract. Moreover, it's also not applicable because the contract wasn't mailed. The only thing that was sent was an email describing a website, describing a contract. So to apply a mailbox rule theory here, really I think this is the mark, because the actual agreement which they seek to enforce was never sent. So I'm happy to answer any further questions. Absent that, thank you for your time.
Thank you, counsel. And counsel, you'll have 1 minute and 49 seconds on it.
Counsel indicated that under the noble review that the local rule regarding the cross appeal was not applicable. That could not be more than wrong. If you look at the Rochelle decision, the review there was de novo, and they applied, and Judge Carr applied that very principle in not permitting arguments to be made regarding an affidavit that had been excluded at the trial court level. So counsel is just flat wrong on that. Counsel also made an analogy in regards to if you throw something in the mail just to a regular John Doe, just because they receive it doesn't mean that it's a contract. He's absolutely 110% correct. But the problem is here is we're talking about in a situation where there's an employee-employer relationship. In the case law, 11 cases that we've cited have applied the very law that he's saying is dead. 11 courts. They've applied the mailbox rule. They've acknowledged that there's an expectation from an employer that an employee will read their emails. And there's an expectation then that if there is not a desire to want to participate in the arbitration, in the solution channel program, that they would simply opt out. She didn't do that here. That was her decision, not Charter's. He also mentioned that there was no evidence that nothing was delivered, or that the email wasn't delivered or received. That's obviously completely contrary to even the trial court acknowledged that there's evidence that it was that the solution channel agreement was received by Ms. McFadden. And that is the exact situation when that issue is at dispute. The case law is instructive across the country that you can go ahead and apply the mailbox rule. There is absolutely no dispute that the email address was correct. There is absolutely no dispute that Ms. McFadden was part of
Counsel, I'm going to have to ask you to conclude.
Thank you. Was part of the group that received it, and Mr. Fries, as the vice president of Human Resources for Technology, had the information available to be able to confirm that there was no indication of any bounce backs.
Thank you.
Thank you.
Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released. And the opinions will also be posted on the Ohio Supreme Court website. Thank you so much.
Thank you.